Hi, everyone. Thanks for joining. Just to kind of get things started, it's just a reminder that if you guys have any questions, you can put them in the chat, but just know that this is a public webinar. We're going to be recording a lot of these aspects. So if there's anything personal or confidential that you don't necessarily want to share with the wider public, don't put it in the chat. I will also note that I cannot answer maybe specific legal questions. At the end of the day, the questions that are asked here and the answers that I give don't establish an attorney-client relationship. And really that's because when it comes to specific legal advice, we need to know more about your circumstances, but I really do try in the context of the webinar and also in our Q&A sessions to try to give you as fulsome of an answer as possible. I'm very excited for today's conversation topic about the October Visa Bulletin. I know a lot of you are very interested and a lot of you are very concerned, or a lot of you are very excited. There's many different ways to kind of interpret it, and I'm here to try to consolidate that information and give you some of the insights that I have and would love to share with the rest of you. So thank you everyone for joining today's webinar about the October Visa Bulletin. We're going to have a Q&A session at the end of this particular webinar, but I'm here to walk you through the Visa Bulletin, how that works, and also why October is such a special upcoming month. Just to briefly introduce myself, my name is Nicole Gunara. I am the principal immigration attorney here at Manifest Law. I've been working in immigration for about 7 years, and I've held leadership positions at prestigious law firms. A lot of my areas of focus are talent visas like EB-1As and O1s, business immigration, generally speaking, everything from the H, the E, the L, the O, J1s, even F1s are a little bit tied into business immigration. But as you've seen here, E1s, E2s, L1s, and other employment visas, I would like to think are a little bit of my forte. But at the end of the day, I have a very comprehensive background, so I'm able to answer a lot of the questions that you may have when it comes to your immigration situation. I also want to introduce a little bit about what Manifest Law is. We are a tech-enabled, tech-forward law firm. We're really trying to change the game of what it looks like for legal practice in the next few years. Essentially, Manifest is really trying to redefine our category to give you the most accessible and best services possible. So going into the agenda for today, we're going to talk about how does the Visa Bulletin even work? It's not like the general public has a lot of great information out there about how to interpret the Visa Bulletin, how it applies to you. So hopefully I can try to demystify a lot of those aspects. Second item that we're going to talk about today are the biggest updates for October of 2025. The reality is that there's a lot to really unpack here. October is a wonderful month when it comes to the Visa Bulletin year over year, and I'm going to give you a little bit of that insight. Then number 3, we're going to break down the EB-1, the EB-2, the EB-3, the changes that have occurred when it comes to this October bulletin update. And number 4, we're going to talk about what this all means for you. And then number 5, we're going to do a Q&A session. Before even this webinar started, essentially, we sent out a registration and some of you had already provided us some questions. So some of those questions will also be answered in the Q&A section, even if you didn't put it in the chat. All right, so reminder, guys, big overview on how the Visa Bulletin works. So for a lot of you who are joining the call, a lot of the focus is on employment-based categories. So your employment-based category, whether it's EB-1, EB-2, or EB-3, determines when you can file your I-485 adjustment of status, or really the next stage of your green card process. To make it very clear, when you file your EB-1 application, an I-140, EB-2, or EB-3, that date of filing generally controls your priority date. Of course, I will tell you that that depends. If you have a perm case, the priority date is set a lot earlier when you file the perm certification, but generally speaking, it's these categories and how you apply for them and when you apply for them that determine something known as your priority date related to the Visa Bulletin. Now, the Visa Bulletin is a monthly publication. It's updated by the Department of State on or about the middle of the month, and it controls when green cards are available. based on your category. So again, EB-1, first preference, EB-2, second preference, EB-3, third preference, and there's a fourth preference and a fifth preference. And it is also something that updates based on your country of birth. The reason why you may have heard of backlogs or how they exist is because demand usually exceeds the annual limits. The government can only issue a certain number of employment-based green cards per year. And because of those annual limits, they have to start setting up cutoff dates on when people can apply for the next stage of the process, whether it's an adjustment of status or whether you are consular processing because you're outside of the United States. Some of the countries that have the largest backlogs are going to be India and China, primarily because of high volume of immigrants and population size. Generally speaking, first preference like the EB-1 typically moves faster than the EB-2 and EB-3. That's because there's less people who generally qualify for an EB-1 category compared to the other two, but all categories can backlog. So I know I said a lot of things. So usually I try to tell people through an analogy or a really clear example, which is what I call the roller coaster example. Essentially, imagine that when you filed your EB-1 or when you filed your EB-2NIW, you get that priority date. Think of that as your fast pass ticket. You showed up to a booth and you said, I want a fast pass. And they told you, okay, now that you're here at this booth, we're telling you that your time is 11 a.m. You need to come back to this roller coaster at 11 a.m. The Visa Bulletin is essentially the clock. It basically says, right now it's 10:30. If your ticket says 10:30, you can go on the roller coaster. So if you have an 11 a.m. ticket, you need to keep waiting until 11 a.m. shows up on the clock, or in this case, the Visa Bulletin, right? So it's because of that, you need to look at your ticket, that priority date. The moment that your date hits on the Visa Bulletin, congratulations, your fast pass is now started. You can go on the ride. And that roller coaster ride being the second stage of your green card process, whether it's consular processing or an adjustment of status. And that's also a reason why the earlier that you sometimes file the I-140 or you start working towards it, the better it is for you. Because that queue ticket or that fast pass ticket, the earlier the number, the earlier it's going to hit. You want to be that 11 a.m. You don't want to be the 12 p.m., the 1 p.m., the 2 p.m. because you're more likely to get into the ride in the first place if you have an earlier ticket. So that being said, October Visa Bulletin. Biggest updates, right? For the month of October, USCIS will be using something known as the filing dates chart and not the final action dates chart to determine whether you are eligible for the next stage of the adjustment of status. Now, the reason why this is such a big deal, right? And I know I didn't explain it in the previous slide because I do not want to go into technical detail, is that every single month, the Visa Bulletin publishes two charts for employment-based categories. Generally speaking, filing dates control when you're able to start the consular process. And the final action date generally is when you're supposed to be able to apply for your adjustment. Every single month, USCIS gets to decide which one of the charts that they're going to accept. But this is that big change. They're using the filing dates, which are usually much more flexible and forward in time than the final action dates. So the reason also why this is so key is getting into the ability to file for your adjustment of status if you're in the United States can net you work authorization, travel authorization, and also the ability to stay here even if your underlying status were to lapse, so long as you timely file and appropriately file your I-485. You're allowed to stay here based on that pending adjustment of status. For many of you, the benefit of the work authorization is going to be really, really strong because you're going to be able to start your own company. You'll be able to work for multiple organizations because an EAD card allows you to do that. So some of the biggest updates, again, for EB-1, it moved forward by 1+ years for individuals who are born in India. And for individuals who are born in China, you're looking at a time shift of about 135 days. EB-2 also moved forward by about 8 months for every country, basically all countries, including 10 months for India. So that is something that you should really consider. EB-3 and EB-4 progressed as well, with a notable forward movement of about 400 days for India in EB-3 and other workers categories, and about 376 days for China. These are significant changes, guys. AOSs are extremely powerful. So for many of you who already have a priority date, who already have maybe an approved I-140, this may be the time for you to really double check the visa bulletin, talk to your immigration attorney to say, hey, am I eligible for an adjustment? Or B, how can I become eligible for an adjustment while the going is good? So let's talk first about EB-1 cutoff dates for the month of October. So last year, in October of 2024, EB-1 filing dates saw no change for China and only moved forward by 2 months for India. So it's actually very surprising, even for a practitioner myself, to see such a dramatic change, right? Things are genuinely moving forward. For India, this is a massive, massive change. So if for whatever reason you always felt like you were in this cycle of having to keep extending your H-1B over and over again, now is the time for you to consider filing an adjustment, especially if you qualify. This is also the time for you to really actively consider an EB-1A if you're in a lower priority category, and we'll talk about some of those tips later on in this presentation. For EB-2, just to kind of break it down even further, movement in last year's October 2024 bulletin was relatively similar. Each country moved forward about 4 to 6 months. This year, though, we did see at least 8 months of forward movement, which is honestly fantastic, right? I will say that I am curious, and we'll find out the numbers in the future of what really drove these things forward. But again, it comes into taking advantage of the opportunity while you have it. I think one of the things that we will discuss in a later slide is how long do we think the government's going to be using the filing dates instead of the final action dates? We've seen some patterns, but I can give you kind of what I think it's going to last until. But again, this might be the time for you to consider, hey, is upgrading from an EB-3 to an EB-2 possible for me? Are there ways for me to take advantage of the fact that these filing dates are now being accepted, which are far, far, far forward in terms of cutoff dates compared to your final action date? And for EB-3, we saw last year actually a retrogression, which was interesting in October of 2024, although India moved forward by about 7 months. India made a bigger leap this year, and China also showed strong movement as well. For all other countries, you saw a 2-month forward movement, but again, these are really, really powerful numbers. So what does this mean for all of you who are, attending this webinar, right? If your priority date is now current, you have a limited window to file your AOS. So now is the time to take action. So the reason why I'm even saying this statement is when the government announced in September that the October Visa Bulletin is going to accept filing dates, they never confirmed if it's going to go into November, December, January, February. What we know right now is that for the month of October, this is what they are accepting for an adjustment of status. So now you kind of have a countdown timer to determine whether or not you are going to move forward with this adjustment. And it's not like an adjustment can be filed overnight. There are things that you need to prepare for in order to get an adjustment of status filed, whether it's the medical checks and medical records that you need to present or your personal records as well. It is still, at the end of the day, a comprehensive filing. If you have an approved I-140 for EB-2 or EB-3, I would also consider upgrading to the EB-1 if you're eligible. If your priority date, let's say, is already current for EB-2, but you're through a perm, but you're no longer working for the company that is responsible for giving you that approved I-140, then the upgrade to the EB-1A, for example, can be extremely meaningful, or really more meaningful for you. Remember, everyone, if your priority date already exists, an upgraded application can absorb that previous priority date. So another way to think about it is that if your EB-2 priority date is not current, however, that priority date would be current if it had been an EB-1, then consider upgrading as well, because then we can use that priority date for that first preference and also potentially concurrently file your adjustment to take advantage of this October Visa Bulletin update. Again, for a lot of you who are sitting here, this is a lot of weird like concepts, right? There's a lot of words that I'm throwing around. It's such a weird concept and it's such a technical process that even I myself, as an attorney, have had to train other attorneys on how to interpret the Visa Bulletin and how to answer it. So the best thing that you can do is always to talk directly with an attorney to figure out if you're current, if you're not current, how you're going to be able to take advantage of the current Visa Bulletin, because there's just so many competing kind of concepts at the same time. And it's not as if the government or really our systems make it really, really easy to understand all of these concepts and how they work together. So I am trying my best here on this conversations, and hopefully this has been a little bit helpful. So now we're at the Q&A section, and I know that we had set aside a lot of time here, and that's because we want to be able to answer as many questions as we can, give you guys the best insights as possible. So I'm here again to remind you guys as a disclaimer, this is a recorded live webinar, not a one-on-one call with an attorney. Please do not divulge any personal or confidential information that you are not comfortable with being shared publicly when this recording is shared online. Keep all comments and or questions as general as possible, because it is very hard for me in my position as an attorney in this public context to answer specific legal questions. So I'm going to go into some of the questions that we received before this webinar even started based on the registration. So I see here that somebody asked, my EB-2, EB-3 priority date is May 2016. I was in the process of doing EB-1A. Should I wait based on the latest Visa Bulletin, or should I still try that as well? So I will tell you from experience that the most successful immigrants are generally people who keep as many options open. I genuinely treat immigration as if it is a stovetop. You want to have as many pots going for you because one of them will come to fruition. It will make the most beautiful stock or soup possible. Because the reality is that in the alphabet soup that is known as immigration, it's hard to predict every single month or even really every single day what changes are going to happen. But changes usually don't come in all of the alphabet soup being recompiled or rechanged. Usually it's changes on individual levels. So I will tell you that my most successful clients are the ones who have an approved EB-3, approved EB-2, and an approved EB-1. If you have the resources to do it, especially considering that you've already invested your time and your resources to start doing an EB-1A, then I would consider or really advise you to consider continuing with that process. Quick reminder for everybody, there is a big difference between the EB-1A and the EB-2 NIW. The reason why I want to remind all of you of these differences is primarily because these are both self-petitioned applications, or can be self-petitioned applications that are within your control that can help you level up your application. So if you have an approved EB-3 I-140 and you want to capture that priority date for the EB-2 or for the EB-1 to take advantage of these updated priority dates, these are generally the mechanisms that you would be looking at. Reminder, EB-1A is for sustained national or international acclaim. You're someone in the top of your field. EB-2 NIW is somebody who is doing work that is going to benefit the United States and also justify waiving of that job offer. Both of them have their merits and are ways for you to get from EB-4 or EB-3 all the way up to EB-2 and then back into EB-1A. Next question that we got is, what is the timeline after an I-485 is filed, right? Or an adjustment of status? It can defer. I find that generally speaking, you should be anticipating about a 1-year timeline before you have a green card in hand. But the reality is that it does depend. Maybe you get called in for an interview, or alternatively, it's luck of the draw, right? And you actually get something that's a lot earlier. I had a client who got their green card approved in about 6 months. So at the end of the day, it really does depend. There is a wide range, but I would anticipate about a 1-year timeline at this moment. So I know that we're at the thank you slide. I'm going to take a look at some of the questions here in the chat. So bear with me 1 second. All right, here we go. So I'm going to scroll up and see some of these questions. So I'm glad there's people from so many different places. Wonderful to see people from Maryland, New Jersey, right over the river, Virginia, Georgia, Boca Raton, and Massachusetts. Spent a lot of time in Massachusetts in my past. So let's see here. Yeah, let me, oh, Okay, there you go. So I stopped sharing my screen. Okay, so let's start with does Argentina have more or less visas approved this year? So we don't have per country statistics just yet. All I can tell you is that for individuals who are born in Argentina, you would be in the all other countries category or the all other chargeability category. So at the end of the day, that means that there's not a ton of high volume immigrants coming from your country. Usually, if there's a high volume of individuals who are coming from a specific country, you would get your own kind of chart in the same way that China and India does. Has the O1 visa criteria changed? I was told that some PhDs are being rejected for O1 even with a good profile. So I know that this doesn't really have anything to do with the conversation for today, but I do think it's important for many of you who are interested in a wide variety of visas. Um, the criteria hasn't really changed. It's just that the scrutiny has definitely gotten a little bit higher. I would say that um, treat the O1 now like an onion. When it comes to evidence, what you want to show is essentially more than just the superficiality, right? Recommendation letters alone are not enough to show that you have a lead critical role. You need to now show corroborating evidence. The government really wants you to prove that you meet each of these criterias. There is no law that says that PhDs are treated better than others in the O1. It's all about whether or not you meet the criteria and those metrics. Next question is, do you lose your E2 visa if you apply for an EB-2 NIW visa? The answer to that question is that when you file for an I-140 application, it doesn't automatically terminate your E2. I think where a lot of people get a bit confused is that when you file an I-140, does it impact the fact that you have an E2? The answer is that it's actually kind of complicated. An I-140 itself technically is not supposed to have a strong impact on the E2. However, the E2 is not a dual intent visa. It is a single intent visa. You're supposed to have the intention to permanently, or not to permanently, to not permanently immigrate to the United States. You're supposed to have the intention to leave the US at the end of your E2 stay. So if you have a pending I-140 or you file for an I-140, the officers who are adjudicating your E2 are welcome to question whether or not you have that intention. Now, there are some protections in the Foreign Adjudicators Manual about residency and how the E2 is governed when you do have these pending applications, but you would need to talk to an attorney to best prepare for that scenario. Can I apply for an EB-1 and EB-2 NIW at the same time, or can I only apply for one? That is a really good question. You can apply for both of them at the same time, subsequently, one after the other. There's no preclusion. You can technically apply for both at any time. I mean, don't apply for it if you already have a green card. That would be a little bit confusing. But essentially, an I-140, they allow you to apply for as many as you would like. I even have clients who applied for a self-petitioned EB-2 NIW while their companies sponsored their own EB-2 NIW, so two EB-2 NIWs at the same time. I have a question here which says, my PD is in April 2022. USCIS currently said that they will respect the date of filing in October 2025. Does it make me eligible for only EAD-AP or both EAD-AP and GC? So I don't know what country that you're from, but assuming that that date is current at the moment and you are eligible to file an adjustment of status, because I don't know the basis of that priority date, like if it's in a perm context and you got the I-140 and you're no longer working for the company, then that's going to make it complicated. But if you are eligible to file your adjustment, you can request an EAD-AP. Now the question is, are you going to get a combo card or two individual documents? Luck of the draw. When can I get work permits or work authorization after applying for either an EB-1 or NIW for rest of the world? It's when you're going to be eligible to file the adjustment of status. I believe for rest of the world, for the EB-1A, once you are approved or you can file it concurrently, the category is current at the moment. So an adjustment can be filed almost immediately. But for NIW, unless you have a previous priority date that could be absorbed that is current, there is a bit of a wait time before you can apply for the adjustment. When you apply for the adjustment, you can apply for the work authorization, and that work authorization can come in anywhere from 3 months all the way up to 6 to 8 months. It just, again, luck of the draw, guys. Let's see here. My I-140 EB-2 was submitted on February 2025. With this October development, can I use premium processing to speed up and take advantage of the filing date, which has started to speed up? So I think I want to make sure that people don't misunderstand here. It's not the date of approval that establishes the priority date, it's the date of filing. If, let's say, February 2025 is current for you, there could be some benefit. The technical question of whether or not you should premium process depends on the strength of your case. I would need to know more, and I am very curious about the basis of your EB-2 and you're honestly one of the best candidates to really consider a full consultation with an attorney to really sit down and see if there's going to be a benefit in you filing for that premium processing. Let's see here. What is the difference between consular processing versus adjustment of status? Very straightforward. Essentially, consular processing means that you are processing that second stage or the green card process abroad. So when I mean second stage, remember that every green card process usually has two stages. For employment-based, the first one is that you need to file for the I-140. That is what proves your eligibility for that green card. In the context of an EB-1A, it's where I argue that you are someone of extraordinary ability. So that's stage number one. Stage number two is that now if you're in the United States for an adjustment of status, or if you're outside of the United States for consular processing, I am now telling the government, please adjust me or change me from whatever I am in that moment into being a green card holder. That second stage is actually where the government does the medical checks, the background checks to see definitely that you would be a good permanent resident for the United States. So when you're saying what's the difference between consular processing and adjustment, adjustment is that you're here in the United States in some sort of valid status and that you're able to domestically here in the US change or adjust from whatever it is that you're in that is valid and lawful into a green card holder. And for consular processing, it's you are abroad and you're going to do the green card process for the second stage through a US consular process. And when you're asking what is filing date versus final action dates, these are the two charts that are published every single month by the Department of State on the Visa Bulletin. I'm going to try my best to keep this as summarized as possible, but the filing date, technically speaking, was supposed to be a chart that told you when you're going to be eligible to file that second stage. And final action dates is basically the date or the cutoff date of when the government's going to be issuing you your visa number or the green card. That's changed a little bit because USCIS has the authority each month to determine which charts that they want to use, but that was the theoretical purpose behind the two charts. Is the November bulletin predictable based on October? Do you think it will advance or retract as it has in previous months? It's hard to say, but what I will say is a positive light is that when you scroll down to the very bottom of the Visa Bulletin, there wasn't really any strong insinuations on the fact that they're thinking that things are going to retrogress. I always tell every single person who looks at the Visa Bulletin, make sure you scroll all the way down to the bottom because the government does leave notes. They really kind of try to tell you like, hey, in the next month, this is what we're seeing, or we're starting to approach X, Y, and Z. And I guess one other note is that historically speaking, dates of filing may extend beyond October. You're looking at maybe into November, December. Generally, it swaps back around January or February into final action. However, at the end of the day, the only proof that we have right now of what they're going to be doing is just for the month of October. We have no idea if in November they're going to be going back or not. For EB-1 India, when do we expect the final action dates to move forward? We don't really have clear, I wouldn't say clear insights, but it's hard to kind of model these things. There are a lot of websites that try their best to get as many statistics kind of pulled together, a lot of research that's put into it. So I would recommend that you consider looking into those sites that are out there. But what I will tell you is that it is an interesting note that final action dates did not move this month. It can mean that there is a high demand for EB-1, but I think the primary focus should be, should I be trying to take advantage of the fact that filing dates are being accepted at this moment so I can get into the adjustment stage because the adjustment stage is so powerful? Will USCIS keep using EB-1 Chart B dates until Chart A catch up with Chart B, or Chart B dates only for this month? So I don't know what you're referencing, Chart A or Chart B, but here's what I'm going to say is that they're using the filing dates for this upcoming month for October. We really only know that it's going to be used for October, and it's not clear if they're going to continue using it into November, December, and the like. When will the priority date of the EB-2W or the PD with priority to may be able to file travel parole and EAD. I don't know what country that you're born in, and it's also very hard to kind of model those things. But May 2025 is very, very recent, so you might have a little bit of a wait time before you're going to be eligible. Once I apply for an adjustment of status, can I travel outside of the United States? Okay. So when you file an adjustment of status, there's two ways that you can have travel authorization. Number one is that depending on the basis of the AOS, and if you are adjusting from an H-1B, a valid and still valid H-1B, a bona fide one, or an L-1 visa that's still bona fide and you're working for that company, you can travel without abandoning your pending adjustment of status. The second way is that when you file for the adjustment of status, you can apply for something known as advanced parole, which is a travel authorization. If you get that advanced parole document, then you can travel, but you need to wait for that document to be issued. EB-2, and no, that's already answered. I am in STEM OPT expiring in February of 2027. I am planning to apply for EB-1 or EB-2 based on my qualifications. How will my work permit be affected by this option? Is there a time when I should file my application? So I will tell you that if you're on F1, if you're considering to travel significantly, there is a concern in you maybe moving forward with an I-140. I usually hesitate because sometimes it can be interpreted when you file for these immigrant petitions that you're interested in permanently immigrating. And the F1 remains a single intent visa. I will say that you're probably someone that would need a consultation to really determine if, not even that if you qualify for the EB-1A or the EB-2NIW or some sort of EB-2 process, but whether or not this is a good idea logistically, or if we can set up a logistical pathway that suits you and your objectives. I see here I'm on an H-1B visa. I have an approved I-140 while I was on F1. Can I be visa stamped for an H-1B now? I just switched to H-1B this year. I was on STEM OPT while waiting my I-140 approval. I don't see why not. An H-1B is a dual intent visa. However, I would still recommend a consultation because I also don't know your full history, right? Were you ever previously arrested? Did you ever fall out of status? These are questions that even if you have a strong H-1B can have your impact in your ability to travel or your ability to get the visa stamping done. Is it possible that in coming months, the USCIS can use final action dates instead of filing dates? Yes, that's the reason why we're strongly urging people who do qualify for adjustment of status at the moment to try to file within October because that's the only proof that we have. There's nothing that says that it's going to extend into November or December or January or February. They can go back to final action dates as quickly as November. I have an EB-1B that I applied for in January 2025. My wife and daughter received a 765 and I-131. I have not received any response. Waiting time for a 45 is 10 months for me and 3 months for my family. I don't know if there's a question in there, but I can only presume that you're wondering if this is normal. The reality is that the government isn't going to take away those benefits or have any impact until your EB-1B has been adjudicated. Well, at least for now, I don't know if there's any rule changes, but next question is, if I have EAD from EB-2, but don't have my final action date current, do you think I should upgrade to EB-1? I mean, I guess my question to you is that if you have an EAD, that means you must have like a pending adjustment of status. There could be some benefits into leveling up to an EB-1 if you're trying to get to the final action date sooner, because the final action date is sometimes what people are targeting to get a green card in hand. My priority date is current under the dates of filing chart, but not under the final action dates chart. What happens if I file my AOS now? So this is like a big question that a lot of people ask because there's a big difference between the filing dates and the final action dates, right? So if you file your adjustment now, it's a good thing, trust me, in the sense that you want to be in that pending status and you want to be at least in that cycle of being in the process of adjusting into a green card. But what this actually means for you if your final action date is not current is that you just won't be issued the actual green card in hand until that final action date becomes current. You would be in pending adjustment of status, quote unquote, in a pending AOS status, and you would be able to maintain an EAD card in addition to travel permits as well if you apply for them and they get approved. How does someone qualify for EB-1 from EB-2 currently? How long does that take? Well, it depends if you qualify to upgrade for an EB-1 category. So EB-1A is the self-petition pathway where you're a person of extraordinary ability. EB-1B is for people who are getting sponsored for being an outstanding researcher or professor. And EB-1C is for multinational executives and senior managers. You are able to upgrade to one of those three sections if you qualify and absorb the priority date that is set in your EB-2 I-140. So in terms of how long that would take, it just depends on which kind of category you qualify for and whether you opt for premium processing. Can I change my jobs on H-1B while waiting for a 485? This is actually a very complicated question because it depends on the basis of your 485, right? If you're basing it off of a perm and it's been pending for at least 6 months, there are ways for you to change your job while maintaining your pending 485, but this is actually a question that's better suited for an attorney consultation because it depends. Once you file all of these things, are you relying on 245K waiver? There's so many different questions that can be kind of added here. And it goes here, sorry for additional context. This is regarding my original question. Well, I think Deborah actually answered it before, right? If you are current at this time, right, and the basis of what makes you current is, let's say it's an EB-1A that's self-petitioned and there's nothing that materially changed in it, then I don't see why you wouldn't apply for an adjustment of status and request for EAD and AP. You won't get the green card issued until your priority date is current on the final action dates. But again, you want to be in that pending adjustment stage where possible to get the work authorization in the AP. For EB-2, what are the wait times for getting a perm approved and also for PWD? It's actually PWD first. You submit a prevailing wage request first, and then you get a prevailing wage determination as a result of that request. Right now, what I usually quote a lot of corporate clients in terms of a timeline for an entire perm process, you're looking at about a year and a half. And then you can file the I-140, but it could take longer. It can take up to 2 years as well. It really is luck of the draw on the agent and also the backlogs at the perm process. Can I apply for EB-2 with a pending asylum? Applied in June 2025, asylum is not promising this time and want to explore as many options as possible. You're on an F1 visa, in status clean records, working on OPT, plan to apply. So I don't see why not. There's no conflict between filing an I-140 and you having applied for asylum, but I think the true question is your underlying status. I know that you said that you're clean in records, but this is where a consultation could be very, very helpful to make sure that even applying for an EB-2 would be helpful for you, and whether or not you're going to even be able to adjust, because I would need to know more. What do you think about the Visa Bulletin for the next few months since the beginning of the 2026 fiscal year has advanced significantly? Looking further back from the past few years, especially from EB-2. My expectation is that filing dates can continue to be what is used in the next few months after, but what's very interesting about this year is that I think all of you guys have seen an increased demand for green cards, right? Whether it's a lot of people are applying for EB-1s or EB-2s, part of it is because they feel unstable at the moment. You have a change of administrations, there's a lot of tumultuous change. So there's this yearning of, can I get permanent residency to feel a stronger sense of stability? And it's because of this high demand that I am curious on whether or not they will continue accepting filing dates even in the month of November or December. But it's hard to say. All I can say is that right now we're confirmed for October and we won't find out for November until about mid-October. Let's see here. I see if I'm currently live on O1B expired next July, can I apply for EB-2 at this point? Depends, do you qualify, right? If you qualify for an EB-2, it might be something that's beneficial, but it depends because the priority dates are not current for those scenarios. And if you've never had a priority date, then we need to be very considerate of your underlying status and you may need to still renew your O1. How the priority date difference between EB-2 NIW and EB-2 perm? It's not different. It's under the EB-2 category. They don't have different, it's not even different dates. There's different there's no different kind of date that's set on the Visa Bulletin. However, in terms of how priority dates are set is different between the EB-2 NIW and the EB-2 perm. So let me explain. For an EB-2 NIW, the priority date is generally set of when you file the I-140 application. For the EB-2 perm, the priority date is set or triggered by when the perm certification has been filed. I have a H-1B work visa. Do I need advanced parole when filing for a 45? You don't necessarily need an advanced parole, but you should just apply for one, has been my general advice. It doesn't hurt for you to have multiple travel documents, especially if for whatever reason you decide not to maintain your H-1B. I was on a valid H-1B, still has 8 months validity. Can I travel for the EB-2 and I-140 self-petition travel out of the country for a week? Remember that the I-140 is not abandoned even if you leave the country. It's when you file the adjustment where you have to be very careful about how you leave and when you leave. But if you're on an H-1B, that's the exception to the rule. Do you do free consults for EB-2 to EB-1? We do provide free consultations for those who qualify. I recommend reaching out to our website or reaching out via our social media, and we'll kind of get you sorted as best as we can. Is EB-1C only for large companies? Okay, so I love this question because I love doing EB-1Cs and I love doing kind of multinational applications. What I will say is that it's not only for large companies, although the government seems to like to see when executives oversee people, but that's not the end all be all, guys. EB-1Cs are actually very nuanced applications. If you find a really good attorney, they will tell you what those exceptions look like and how to build into the right direction for an EB-1C or a solid application. Uh, Do you think final action dates for EB-2 India will move forward soon? We've been waiting for our green card since 2021. What would be the best action in this scenario? Consider upgrading to the EB-1. If you qualify for an EB-1A or you're willing to put in the effort or like the work into trying to get into a qualifying position for an EB-1A, then that would be a way to really accelerate or try your best to accelerate you actually getting the green card. Because what I'm assuming from this question is that you've applied for the adjustment of status based on the EB-2, but you've still been waiting because your final action date hasn't become current, and you really want that green card in hand. So one way to do that, EB-1. What would be the timeline for a registered nurse present in the USA now working on a TN? So I think it depends on what category you're going to qualify for. So if you're a registered nurse and you have an appropriate job that's willing to sponsor you, you should consider a Schedule A filing. But Schedule A can fall under EB-2 in some circumstances or EB-3. So the wait time really depends on which category you end up qualifying for, and also to some degree the pacing of your employer of wanting to go through the process. Because Schedule A, you can skip parts of the labor certification process, but you still need to do one part of it that can take a little bit of time. Sorry if I missed what you said. Did you say that the work permit might be issued while the AOS is pending based on the final action date? No. If you file an adjustment of status and you qualify for filing an adjustment of status, even if your final action date is not current, remember for the month of October, they're accepting filing dates for adjustment of statuses. While the AOS is pending, you can apply for that work authorization document, the EAD, and they will or they should, unless you don't qualify for it for some reason, get the EAD card issued. But when that gets issued depends on the luck of the draw. You can get it issued within 3 months of filing for it based on your pending AOS, or it could be as long as like 8 months. Uh, Okay, so that's kind of most of the questions because everything else is a little bit too detailed, guys. When you guys are giving me like these paragraphs, it makes me feel that it might be better suited for you to do a consultation. Please note that for certain individuals, you can qualify for a free consultation. Our firm really does try our best to answer as much as we can, give you guys as much as we are able to in terms of answering your legal questions. So please feel free to reach out to us. I think our team will list down very quickly. Let's see here. Uh, yeah, so for the person who's saying like, can I get more information about eligibility? Please reach out to Zach, and then we can try to get you onboarded. But yeah, please request for a consultation. Hopefully today's conversation was very helpful for you all. I know that a lot of you have so many questions, and I really do try my best to answer it. But let's see here. Uh, Okay, I'll try to answer this last one. I have a PWD already approved. Can you tell me what is the wait time for perm for EB-2? So if you are after the PWD, remember that you still need to do the recruitment stage. The recruitment stage can be anywhere from 60 to 90 days, unless they somehow did concurrent recruitment, which is quite rare in this industry. And then after that, they would need to file for the perm certification. Right now, it's been about anywhere from 6 to 9 months, but I've seen it take longer, so it really depends. And after that perm is certified and given back to you, then you need to file for the I-140. But anyways, I know that there's a lot of questions here, but these are very detailed questions that people are asking me to answer. So please schedule a consultation and we'll try to get back to you. Okay, so thank you everyone for your time.